Right, excellent. Good morning, good afternoon, and good evening from wherever you're joining us today. And a very warm welcome to this significant and timely conversation. This webinar will mark the final and the fifth session in the International Law Month series at Kabarak University Press, which essentially is an annual month-long initiative dedicated to highlighting international law questions that are most relevant to the Global South today. By way of brief introduction, my name is Macharia, and I have the privilege of moderating today's session on reviewing the climate change advisory opinions. I am a recent law graduate from Strathmore Law School in Nairobi, Kenya, and currently serve as a research assistant at the Strathmore Institute for Advanced Studies in International Law. As you recall, on the 13th of June 2023, the Kabarak University Press, together with the African Society of International Law, as well as the Jindal Global Law School, co-hosted a webinar reflecting on the opportunities for the Global South in the then pending climate change advisory opinion. And today we're here to resume that very conversation from 2 years ago, at a moment of unprecedented urgency. And in this period, the past 2 years, we have witnessed an extraordinary convergence of international bodies, from the International Court of Justice to the Inter-American Court, as well as the ITLOS, the International Tribunal for the Law of the Sea, each tasked with clarifying state obligations in responding to anthropogenic climate change. And so collectively, these advisory opinions, they represent a historic moment in the evolution of climate governance. It provides an unprecedented opportunity to clarify the normative content of the governing legal framework, especially obligations under the climate change treaties. And so today's sessions aim to do more than simply restate what these opinions say. Our purpose is to interrogate these opinions, to explore the implications of these opinions for states, international organizations, and even vulnerable communities and all stakeholders, and consider how these opinions might shape the future of global climate governance. And with me today, we are distinguished to have a panel of experts to guide us through these pressing issues. They bring both scholarship and practical experience in climate litigation and policy, and I will introduce them shortly. But first, let me sincerely thank you all for taking your time to join us, as well as recognize the host of this webinar today, the Kabarak University Press, as well as the Center for International Law at National University of Singapore for convening this important forum. Most importantly, I would like to remind the audience that Kenya has a candidate for the International Court of Justice, and we are pleased to highlight the candidacy of Professor Phoebe Okoa for the election to the International Court of Justice this November 2025. Per se, Professor Okoa has been a distinguished Kenyan jurist and a close friend of Kabarak University Press, and who also honored us with her presence during our previous webinar on climate change. So to begin our session, I'm delighted to invite one of our co-organizers, Rashmi Raman, who is a research fellow at the Center for International Law at National University of Singapore, to deliver some opening remarks and provide a brief reflection of our previous webinar 2 years ago, when we were reviewing the then pending request. Rashmi, thank you for being with us today. The floor is yours.
Thank you, Albert. Thank you, Humphrey, and good evening to everyone from Singapore, and a very warm welcome to this webinar. At the NUS Center for International Law, we are happy to convene this with Kabarak University in Kenya, and I am delighted and honored to be here among distinguished colleagues and dear friends on a panel that brings together a critical mass to discuss the next steps in international law's climate change advocacy journey. 2 years ago, as Albert said, in the June of 2023, we convened a webinar to ask what a flurry of advisory opinion requests might do to move the needle on climate change. At that time, we noted how advocacy leadership was coming from the Global South, often from so-called small states, and how these coalitions were reframing both the venue as well as the voice of climate adjudication. Today, we return with familiar colleagues and new friends to take stock of what the delivered opinions say, what they changed, and how they set the stage for a fourth advisory request now before the African Court. Colleagues, over the past 15 months, 3 advisory opinions have transformed the legal landscape for climate action. They give us clearer duties, tighter standards, and a shared vocabulary that courts, regulators, communities can use right now. First, the International Tribunal for the Law of the Sea spoke from Hamburg on the 21st of May, 2024. ITLOS held that greenhouse gases released into the atmosphere and absorbed by the ocean are pollution of the marine environment under UNCLOS. That single move unlocks Part 12 toolbox. States now owe stringent due diligence guided by the best available science and the precautionary approach. They must cooperate, monitor, assess published results, and assist developing states with capabilities shaping intensity but not the existence of obligations. In short, on the ITLOS opinion, pollution law now speaks to the climate. Secondly, the Inter-American Court delivered on the 29th of May this year its advisory opinion, in which it framed the climate emergency as a human rights problem and recognized the right to a healthy environment, including a healthy climate, with both a collective as well as an individual dimension. On that basis, the court spelled out concrete duties to mitigate emissions, regulate, supervise private actors, protect sinks, regulate environmental impact assessment, ensure participation, information, and access to justice. It also traced an emerging line on nature and the ecosystem as a rights holder, strengthening the protection of ecosystems as such. And most recently, on the 23rd of July this year, the International Court of Justice answered the General Assembly's request with a deep and wide reading of the international law questions that it involved. The court linked due diligence, prevention of transboundary harm, and human rights to clarify that states must act to avert foreseeable climate harm, and that, very importantly, they can incur responsibility for failures, including failures to regulate private emitters. Many commentators elsewhere have highlighted that the opinion aligns state ambition with the 1.5-degree pathway and now puts adaptation obligations on an equal legal footing with mitigation, with consequences ranging from cessation to reparations. The court also noted regional jurisprudence of the Inter-American Court. So what ties these 3 advisory opinions together are 4 practical shifts. 1, the benchmark. Between the ITLOS and the ICJ, due diligence is no longer a best effort slogan. It is a high evolving standard. It's informed by science and precaution and sensitive to risk and capability. That makes under-regulation of fossil fuel production and subsidies legally risky, not just unwise policy. 2, the addressees. All 3 opinions confirm that obligations bite on states, but their content includes duties to control private actors. The message is simple. If emissions are foreseeable and preventable through regulation, licensing, supervision, or withdrawal of support, inaction can trigger responsibility. 3, the evidence. ITLOS operationalizes the best available science and precaution for oceans. The Inter-American Court constitutionalizes participation, information, and access to justice. The ICJ folds both into a general law frame that domestic courts can pick up. Together, they lower the evidentiary temperature for urgent measures while insisting on transparent reason giving. And 4, the remedies. The ICJ confirms classic consequences of wrongful acts, and now we have a link to ambition, mitigation, and adaptation in one legal calculus. So this opens the space for cessation, guarantees of non-repetition, and forms of reparations, and which deepens who and what must benefit from the remedy. A striking set of procedural trends also sits alongside the substance. The ICJ climate opinion drew record participation with 91 written statements, 62 written comments, and oral presentations by 96 states and 11 international organizations, including several first-time state appearances, which signals a broader entry of small and climate vulnerable states into global adjudication and a widening sense of ownership over the court's climate docket. This opening was also mirrored at ITLOS, where over 30 states and multiple intergovernmental organizations filed written statements, and more than 30 states spoke at the hearings in the COSIS request, reflecting a high level of engagement for a specialized tribunal. Coalitions have also become institutional actors in their own rights. COSIS convened small island states to strategically use advisory functions, and this was highlighted at the recently, just today concluded, American Society Abroad conference in Singapore in a brilliant panel yesterday, which spoke about the formation of COSIS was for requesting advisory opinions. First-time appearances by states such as Barbados, Nepal, and the Cook Islands underscore how advisory proceedings can lower entry costs and broaden participation, with downstream effects on legitimacy and diffusion of climate legal norms. Finally, the advisory cycles have normalized reliance on cross-institutional inputs and amici, with tribunals openly integrating scientific bodies, regional organizations, and civil society materials into the record. A practice that both democratizes the idea of adjudication and also creates significant challenges going forward. Now, the arc of these advisory opinions bends towards Arusha. On the 2nd of May this year, the Pan-African Lawyers Union, together with the African Climate Platform, Natural Justice, the Environmental Lawyers Collective for Africa, and Resilient 40, lodged a request for an advisory opinion before the African Court to clarify the human rights obligations of African states in relation to the climate crisis. We sit here today with experts, friends, and colleagues to debate and deliberate on what the road ahead means and what it holds, what challenges may come, how we can work together to understand more deeply and engage more actively in this fascinating journey of advocacy and litigation of international law before regional and international courts and tribunals. Thank you, and I look forward to today's exciting panel. Albert, over to you.
Thank you so much, Rashmi, for the opening remarks. Indeed, your input confirms what exactly we did predict on the 2 years ago, June 2023. The 3 notes speaks towards what Professor Makan spoke about cross-fertilization of laws, both procedurally and substantively. Now, to dive and to kickstart the conversation, we are going to start with an input in trying to understand the advisory opinion of the International Court of Justice. And I'm happy today to introduce Samira Ben Ali, who will be our first panelist, who will be helping us dissect and understand the decision, the advisory opinion of the International Court of Justice. A very brief bio, very, very brief in the interest of time. Samira Ben Ali is a global campaigns lead for the world's Youth for Climate Justice, where she builds partnerships and mobilizes youth around the historic advisory opinion process on climate change before the International Court of Justice. She is also the European Economic and Social Committee Youth Delegate to COP for 2025 and 2026, as well as an EU Climate Pact Ambassador. Thank you so much, Samira, for joining us. The floor is yours.
Thank you so much, Albert, and thank you again for this invitation. Rashmi has already said a lot of the introductory element that I wanted to mention, so that is perfect for me. I can just directly dive in. Just maybe one point that I always like to emphasize was that this initiative was started in 2019 by young people from the Pacific, and then it really became a global youth movement. And myself and José and other young people from across the world, as part of World for Climate Justice and also other movements, really tried as much as possible to make sure that this advisory opinion came what it is right now. Maybe again on the request a little bit, just to frame the question so that we all go into this conversation together. On the 29th of March 2023, the UN General Assembly adopted the resolution for the advisory opinion by consensus, and that the question that were asked, the two core questions, were regarding states' obligation to protect the climate system and the legal consequences failing to do so, especially for small island states and also for future generations. And as was mentioned previously, back in July of this year, we were able to get, finally, after 6 years of campaigning and work together, this advisory opinion, which was a huge positive moment, I think, for all of us. It was a moment where really the ICJ took a bold step toward climate justice. When it comes to the core of what the ICJ said, I will have to really make choices on what is the most important because it's a really long document, 140 pages. So in 10 minutes, I'll try to just make mention of the most important elements. I think that one of the thing that I always like to start to when it comes to the ICJ is that it came again on the importance of science. It reaffirmed the importance of the IPCC and how this must be our guiding light when we treat subjects in regards to the climate. After that, another really important element is that it reaffirmed again the legal framework from which we're talking about. The ICJ clarified that states' obligations on climate change are not confined to climate treaties. They mentioned that state obligations under international law concerning climate change extend beyond the specific climate treaties, including but not limited to customary international law, especially to prevent transboundary harm and to cooperate, the UN Convention of the Law of the Sea, the Convention to Combat Desertification, the Convention on Biological Diversity, and the International Covenants on Civil and Political Rights, and Economic and Social and Cultural Rights. They made mention of the fact that the climate treaties are complementary. UNFCCC sets somehow the principle, and the Kyoto and the Paris agreements operationalize the obligation, including mitigation, adaptation, and differentiated responsibility. And crucially, they made mention of the fact that the treaty and customary law mutually inform each other, and climate treaties do not exclude the application of other international rules. The court also went over to reaffirm what are the state responsibility. It reaffirmed that the general law of state responsibility apply to breaches of climate obligations. Cooperative mechanism under the UNFCCC and Paris agreements, like the loss and damage fund or compliance committees, do not replace or override these established international rules. And also that they may therefore be held internationally responsible if they fail to act with due diligence to prevent climate harm. They also took the time to detail what were the core substantive obligations that we were talking about. They made mention of the duty of prevention and due diligence. The customary duty to prevent transboundary harm apply, as was also mentioned by our previous panelists, fully to climate change, requiring stringent due diligence. And that is really something that we must make an emphasis on. States must take all measures available to them to avoid significant harm, guided by equity and common but differentiated responsibility and respective capabilities, and also best available science. The court also affirmed that states must protect human rights, including the right to life, health, food, housing, and healthy environments. And especially they made mention of the fact that having a healthy environment is a precondition for us being able to live together. They also made mention of the fact that states must regulate both public and private actors under their jurisdiction to achieve, and I quote, deep, rapid, and sustainable reduction, end quote, of greenhouse gas emission. Failure to act on fossil fuel production, licensing, or subsidies may amount to an international wrongful act. And then they went on to answer the second part of the question that is really on the consequences of the breaches. And if they felt its obligation, there is a full suite of state responsibility consequences that apply. That means cessation, guarantee of non-repetition, so stopping the wrongful act and wrongful conduct, such as, for example, harmful subsidies, excessive emissions, but also reparation that can take several forms, of course, and that is really something that is a case-by-case basis. But some mentions were made of maybe restitution, compensation, satisfaction measures. And what we mean by those terms, restitution, for example, can mean restoring a forest. Compensation can be on the term of financial loss, or satisfaction can be in terms of an apology, an acknowledgement, something that is necessary for the community that has been harmed to be able to move forward. Also, because those responsibilities are erga omnes, so that they are owned by all states. So any state can invoke responsibility, not only those directly injured. This has several ramifications, in particular in terms of litigation. I think this is a really significant moment because it allows us to strengthen the legal grounds that we were already working on. With this advisory opinion, we confirm that state obligations stem from both treaties and customary law. So this expands the basis of litigation beyond climate treaties alone, which is a good thing for people who maybe want to go and use that road. There is a higher due diligence standard that has been set by the court. There is a clear mention of the fact that national policies on exploration subsidies and licensing can now be scrutinized as potential breaches of international law. The human rights link has been reaffirmed. So the trend that we have been seeing all over the world of linking human rights litigation with climate harm can now be more, again, reinforced, and maybe we'll be able to see more of such cases. And last point on this particular consequences on litigation is the fact that because those obligations are erga omnes, even states not directly harmed by may bring claims. So it's opening a pathway to broaden international climate litigation. However, this opinion is not considered as perfect, even by the judges who, I must say, by consensus, have drafted this. Some of them, in particular, reading the statement written by Judge Joseph and Judge Subuntide, where they mention the fact that this opinion didn't maybe go as far as it could have. They argue that the court, by taking an overly formalistic and abstract approach, treated all states as if they bore the same obligation toward climate change. Judge Yusuf, in particular, used the quote saying that there is a kind of majestic equality of the law that ignore empirical realities, scientific evidence, and the principle of CBDR. So they stressed the fact that the request for this advisory opinion explicitly is rooted in the concern of climate justice, especially for small islands, developing states, so SID, and other vulnerable developing countries. He also mentioned the fact that CBDR and historical responsibility are central for international climate law, as is reflected in several of the treaties that we already know of, and climate, for example, the Rio Declaration, UNFCCC, Kyoto, Paris. So this is something that should have been put more of an emphasis on. And by ignoring, and the court didn't make enough of a differentiation between the greater obligations of developing states and the obligations of developed states towards them. And by ignoring this differentiation, the court has disregarded the fundamental disparities in terms of historical and current contribution to climate change. And so it's putting some kind of like unequal burden to states. And also the CBDR is not just about the past, it stresses present and future inequities between industrialized and developing countries. So we can see that this opinion is not perfect in that sense. However, it is still a lot that was given to us. It is still a lot, and it's also open. It also opened the pathway for the new advisory opinion that we may see soon from the African Court of Human and People's Rights to do more and to answer some of the gaps that have been left open. The African Court could center vulnerability by integrating state obligation under the African Charter and made more light on the impact of marginalized communities such as indigenous communities, pastoral communities, coastal communities, women, children, and it could do more in that sense. It could, of course, smoothen the gap that was left in terms of CBDR, given Africa's negligible contribution to historical emission. The court could explicitly affirm that CBDR is a binding principle of international law that shape African state obligation, both internally and externally. It could also strengthen the protection of climate displaced persons and communities. That is something that we have not seen that much. It could expand on reparation doctrine by making the context more relevant and also the expanding on the solutions. I think that especially when it comes to reparation from the African context or global South context, I think that the historical nature of reparation is extremely important, and it also needs to lead to conversation maybe around decolonization and all that comes from that. So that could be an interesting conversation to have in these particular courts. And obviously, the African Charter has both individual and people's rights. So that could be something that we could see from that particular court. I will stop it from here as I need to leave right now for another event, but I'm happy to take the question that you may have. And maybe José could share my email to all of you if you have any specific question, and looking forward to watch the recording. Thank you so much. Goodbye.
Thank you so much, Samira. And thank you so much for gracing your attendance with us today. To pick up from where Samira left, one of the key points was that the discussion in the International Court of Justice was not necessarily a perfect one, because the International Court of Justice failed to unpack properly the concept of CBDR. And in fact, this is very evident in the separate opinion of Vice President Sebutinde. And as I will hope to hear even from the request for advisory opinion in the African Court, the question of CBDR and the question of state obligations with regards to global climate change, governance, and related obligations, it's really a concern. And even with regards to the devastating impact of vulnerable personnel, such as children, such as women, this is some of the concerns that have been raised in that request for advisory opinion before the African Court. Thank you so much. I've seen we have a lot of questions. We shall be taking these questions towards the end of the webinar. We have a Q&A session. Now, before we proceed to the ITLOS, we are going to have a recording from Professor Oral, who unfortunately she's not able to join us today. I'll read briefly her bio, that she's a member of the United Nations International Law Commission. She was elected in 2017. She's also the director of the Center for International Law at the National University of Singapore. She's also a member of the Curatorium of the Hague Academy of the International Law and is an associate member of the IACtHPR International. Dr. Oral served as the legal advisor to the Turkish Ministry of Foreign Affairs between 1998 to 2016, where she represented Turkey in numerous international negotiations. particularly in the field of law of the sea and climate change. So I'm going to hand over to the control room to play the recording, to play the message that Professor Oral had for us today.
Greetings to all of you, and a special thank you to Kabarak University for the invitation to speak at this conference webinar on the advisory opinions. Regrettably, I cannot be with you in person, so I'm sending this recording, but I did want to participate, and a special thanks to Humphrey. So what I'm going to do is basically give my own personal opinion and highlights of what I think some of the core issues that came up in the advisory opinion that was rendered on the 23rd of August by the International Court of Justice. Now, I'm sure you will all remark, one thing that immediately stood out was that the decision was unanimous. This is quite rare to have the World Court with its 15 judges coming from rather different backgrounds and views to have a unanimous opinion, which definitely adds extra legitimacy and weight to this historic landmark opinion. Second, also what's very important was that the court started off really emphasizing science. And you can see that the opinion was very much driven by the reality of science concerning the impacts of climate change, global warming, and the whole issue of the temperature rise of 1.5 degrees centigrade. So science was a very key aspect of the decision. And in this, for example, the opinion made the statement that the consequences of climate change are severe and far-reaching, that certain species are being pushed toward extinction and irreversible loss of biodiversity, that human life and health are also at risk, and that these consequences underscore the urgent and existential threat posed by climate change, and the court used existential threat. Now, after that, the court went on to look at the legal issues and starting, of course, with the sources of international law. And one thing that struck me was the court was very methodical and precise in its analysis of the sources of international law applicable to the opinion. Now, unlike, for example, the ITLOS advisory opinion, which centered exclusively on the law of the sea convention and customary international law, this advisory opinion was quite broad. The request itself cast a rather vast net that included pretty well all international treaties that would be relevant. In particular, of course, the climate change treaties, the Law of the Sea Convention, human rights treaties, and others. So in assessing which sources to take into account, the court started off, of course, with the climate change regime. And what I really found remarkable was that the court looked at all three instruments. We tend to focus a lot on Paris, the Paris Agreement, but the court didn't do that. The court started off with UNFCCC, the Framework Convention, and in that focusing on the ultimate objective of the Framework Convention as stated in Article 2, which is the stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. This has often been forgotten as we've focused, understandably, on the temperature target under Paris. What was quite remarkable, in my view, was the court resurrected the Kyoto Protocol, stating that, that the court considered that the lack of agreement on a further commitment period under the Kyoto Protocol after the adoption of the Paris Agreement does not mean that the Kyoto Protocol has been terminated. So the obligations continue. And this is something that we have not really been discussing, although I understand it was an issue raised in some of the statements by delegations. And also, the court adopted a number of principles, but the only one that excluded was a polluter pays principle. And this was picked up by one of the separate opinions of the judges. Of course, important principles, significant harm was something that the court focused on as well. Again, one of the key issues had to do with the status of the climate change regime, particularly the Paris Agreement being lex specialis, and therefore really having the ultimate say on the obligations of states, as some states argued, versus that customary international law. And this is where the issue of significant harm came in, that the obligation to prevent significant harm as a principle or a rule under customary international law still applied outside of the climate change regime and Paris Agreement. And this is clearly what the court said. Also, the court referred to mutual supportiveness and systematic integration, something that was raised by many states, and saying that the climate change regimes, and particularly a Paris Agreement, were to be interpreted systematically in a way that's consistent with other rules of international law. As we know, I think one of the stars of the opinion, and this was also in the case of the ITLOS opinion, was due diligence. And on this point, the court adopted the same standard as the ITLOS opinion, but I would say more broader, that the due diligence obligations of states to protect and preserve the climate system was stringent. And so that is very, very clear, establishing a very, very high standard. And I just want to say that when it came to the law of the sea issues, the court really deferred to the International Tribunal for the Law of the Sea and their opinion. And in paragraph 338, the court said that since its establishment, ITLOS has developed a considerable body of jurisprudence on UNCLOS, both in contentious and advisory proceedings. Although the court is not obliged in the exercise of its judicial functions to model its own interpretation of UNCLOS and that of ITLOS, it considers that insofar as it is called upon to interpret the convention, it should ascribe great weight to the interpretation adopted by the tribunal. So, and as a source of law, of course, not just well, the source of law, it's the Law of the Sea Convention, but the court really cites the opinion of ITLOS over and over and over again. So we can conclude from this that when it comes to law of the sea issues, the ITLOS opinion really is the core. Another very interesting point I found, and others I'm sure as well, is how the court treated COP decisions, that is, Conference of the Party decisions. And in this case, these are, of course, decisions adopted by parties to either the UNFCCC, the meetings of the parties, Kyoto, or Conference of the Meetings of the Parties for the Paris Agreement. And the court basically said in certain situations, these COP decisions can be binding, one, if the treaty convention so provides, or as part of subsequent agreement, subsequent practice. And this is how they tied in the 1.5 degree temperature target as being now a COP decision based on subsequent agreement. Now, this treatment of Conference of the Party decisions, I think will have some repercussions and something to talk more about. But again, I just want to highlight some of the issues that I found that were really interesting. Also, on nationally determined contributions, NDCs, Now, NDCs were intended to give states flexibility and discretion in the so-called bottom-up approach to mitigation obligations, understanding always that the developed countries still had to take the lead. But on this score, because of the science, because of the existential threat of climate change, the court basically, the court stated that the court considers that the discretion of parties in the preparation of their NDCs is limited. So states don't have that much discretion. And so the notion that some have taken the view that the Paris Agreement is soft law, I think, has been put to rest by this opinion. And in addition, the court made quite clear the historical responsibility of Annex 1 and Annex 2 parties and their higher level of obligation, both for mitigation and financial support. In addition, the court really stressed the obligations of the duty to cooperate and also the role of equity, as well as the precaution principle or approach. So I just want to make, there's a lot more, but I don't want to take up too much time. And the one thing I do want to say in my final comments, of course, had to do with the court's comments on sea level rise. It was not part of the questions asked of the court and the request for the advisory opinion by the General Assembly. However, many states brought up sea level rise and the impacts, one, on maritime boundaries, two, the issue of statehood, and also protection of persons did come up in written statements and the oral statements of many states. So we were very surprised, but very pleased that the court actually unanimously referred to sea level rise and referred to the work of the International Law Commission. And of course, as one of the co-chairs of the study group, we were very happy to see that, and essentially endorsing the view that was taken up by the commission that states do not have to update their baselines or charts once they have been duly established, that there is no provision in the convention requiring states to do so. And this was the conclusion that we had reached in the commission. Also, the opinion addressed the issue of statehood and stated that once a state is established, the disappearance of one of its constituent elements would not necessarily entail the loss of its statehood. So it's a little nuanced from what the Commission's position is on the continuity of statehood. And I think we can see why in Judge Tomka's separate opinion there. Also, we know that the court, referred quite a bit to human rights, made some very important statements there on, but maybe others will talk about that. So I will just stop here and state that it is really a powerful opinion. I think it went further than many expected. I think the court went into areas that didn't have to really, but it did. And it seems to me that the court was fully aware of the historical responsibility lay upon its shoulders with this opinion. And yes, while some think that the court could have done more, sure, but I think that's unrealistic. I think that this is really the best we could have expected, especially since it's a unanimous opinion. Anyway, I wish I were there to talk to you more about this fantastic opinion. I think we'll be talking about it and writing about it for quite a bit of time to come, but I wish you all an excellent conference and webinar. Thank you so much.
Thank you. Excellent. So before I proceed, I'd like to welcome and name Professor Helen Tigroja, who is the chair for the Human Rights Committee, as well as Professor Chris Givers, who is the director for Center for Applied Legal Studies at the University of Witwatersrand. So you're welcome. Now, those are the two panel discussions regarding insights into that ICJ advisory opinion. Now, if you have any question, you feel free to paste the question at the chat box. You're going to take them at the end of the session. We now proceed to insight into the ITLOS advisory opinion. And I really like the ending note of Professor Oral regarding the ICJ's pronunciation with regards to the question of sea level rise. We know that they pronounced that there is no obligation to update the chart. So I really wonder, what does this mean to Article 5 of the UCLOS? Does it mean, how do we determine the baselines in accordance to the Law of the Sea Convention, in particular, Article 5? So I'd like to welcome Professor Gudmundur, who will be taking us through this session. So a very brief bio about Professor is that he's a Professor and Executive Director of the Center for International Legal Studies at the Jindal Global Law School. He's currently a member of the Panellists of Conciliation and Arbitration under the United Nations Convention on the Law of the Sea from 2013 to date, as well as a member of the Panel of Conciliators and Panel of Arbitrators at the International Center for Settlement of Investment Disputes from 2010 to date. Thank you so much, Professor, for joining us today. The floor is yours.
Thank you so much, Albert, and I thank the organizers for inviting me to participate in this very important topic, discussion of this very important topic. I just want to begin by saying I'm not planning to say anything about sea level rise, and I'm happy that Professor Nilüfer has some comments about what the ICJ said about that. I'd like to structure my presentation as follows. First, 2 premises. Second, 2 disclaimers. Third, 8 points on the substance of the ITLOS advisory opinion. And lastly, some final thoughts about a possible future. If I turn to the first premise, I rush to declare at the outset that the ITLOS advisory opinion is a magnificent one. In its scope, its legal and scientific precision and attentiveness, not only, I would say, attentiveness, but not subservience to its political ramifications. For that matter, I also commend colleagues from the various countries and international organizations who have contributed to this process in their presentations before the tribunal. Before the decision was announced, I had spoken frequently and expressed the hope that it would be groundbreaking, and indeed I find that it is. So I use that word again, and particularly when aligned with the other decisions we'll be discussing here today. And like Professor Nilüfer said about the ICJ, I was very pleased that the decision was unanimous. Of course, I was also by Professor Nilüfer. And while I'm on this topic, to express my appreciation of much of the recent work done by the International Court of Justice on very many important issues of our times. They've done amazing work, and I won't go into that here, but just I want to use this opportunity to congratulate them. Well, my second premise is perhaps obvious, that it is not up to me or people like me to make use of the decision. That is, use the ITLOS decision to change the global approach to tackling this dire situation. And I'll return to this point in concluding. As for my disclaimers, I begin by admitting that I became very early, up to 3 decades ago probably, not a, quote, climate change denier, quote, but a climate change negotiations denier. And this links into what we've heard already from our colleagues. My former students and other colleagues may recall that I have very often related my experience in the negotiations for Agenda 21 preparatory to the Rio conference in 1992. In my frustration during that exercise, when one proposal after another, including from my government, were dismissed, I ended up suggesting to the chairman that he ask, whenever a proposal was made, to ask whether any delegation thought it actually meant anything, in which case they would raise their hand and it would be taken off the table. I was actually appalled to find that this suggestion that I made met with a lot of support, and I had to ask for the floor to say that I was being sarcastic. But that's the framework in which I proceeded on this, shall we say, actually most environmental questions. As a part of this disclaimer, I would point out that although I was very active in the negotiations at the third UN conference on the law of the sea, I had next to no role in the negotiations on the protection of the marine environment. And thus, to take one example, which which ITLOS featured, I could be excused for not reading Article 192 of the Convention, which is extensively dealt with by it, as laying down a clear roadmap for the future. How otherwise can one read a sentence, and I quote, "States have the obligation to protect and preserve the marine environment," full stop. And I would welcome the comparison with this broad statement with the situation today, and of course, in particular, in the issue we're dealing with today. Well, my second disclaimer is a rather more petty one, that dealing with the jurisdictional dispute before the tribunal. That is, whether it was acting ultra vires in providing in its rules for the possibility of advisory jurisdiction. I must admit I was apprehensive when this matter first was raised I say our because I can't get out of the habit of calling it my tribunal. When it was first raised in the first request for advisory opinion under the rules of the tribunal. I'm glad that the controversy has somewhat abated in the context of the request we're discussing now. Anyway, I say disclaimer because I was involved in the adoption of that rule, shall we say. Now I have to be careful here, which ended up being the jurisdictional basis for the two advisory opinions we've already laid down. Well, I turn now to the 8 points, which I'm setting out in very brief form on the substance of the advisory opinion. The first is perhaps not strictly substantive, but rather relates to the extensive discussion in the opinion on whether the tribunal should, in its discretion, have refrained from answering the request. And I would only say, you may think cryptically, that it is not advisable to link any such discussion to the practice of the International Court of Justice. Now, second, as Rashmi has already pointed out, the tribunal affirmed that anthropogenic GHG emissions into the atmosphere constitute pollution of the marine environment within the meaning of Article 114 of the Convention. This was, of course, a relief and a precondition to dealing with the request. Here I interject again cryptically a thought on the decision at the time not to include in Article 1 any terms from the articles dealt with by the Second Committee of the Conference. My third point is to express my relief that the tribunal did not consider that the obligations under Article 194 of the Convention would be satisfied simply by complying with the obligations and commitments of the Paris Agreement. This is in line with my view set out earlier on the efficacy of international negotiations. Fourth, as I said earlier about the tribunal's sensitivities with respect to political considerations, it was of course required, the tribunal was of course required to address what it identifies as the principle, and they use that word, principle, of common but differentiated responsibilities. Without saying more, I would refer to paragraphs 226 and 229 of the opinion. At the end of the day, in the opinion, this concept finds resonance in each of the specific answers through introduction of a clause, and I quote, "The scope and content of necessary measures may vary in accordance with the means available to states parties and their capabilities." So this must ring a bell in that context. Fifth, and as we turn to the crux of the decision, the tribunal adopts as a kind of a mantra the reference to the obligations set out in various articles of the convention as, quote, specific. So I have a list of 1, 2, 3, 4, 8, 10, 12, 14, 16 references. And as to the nature of these specific obligations, I quote again, the quote, the tribunal lays out what we've already heard referred to in our previous contributions, and I quote, in the view of the tribunal, what is required of states under this provision is not to guarantee the prevention, reduction, and control of marine pollution at all times, but to make their best efforts to achieve such result. And then it continues, it is thus the conduct of a state, not the result which would be entailed by the conduct, that will determine whether the state has complied with its obligations under Article 1941 of the Convention and the commitments. And it goes on in a subsequent paragraph to say, since Article 194.1 of the Convention provides for an obligation of conduct, it requires states to act with, quote, due diligence in taking necessary measures to prevent, reduce, and control marine pollution. Now, I think anybody that knows me well through my lectures and so forth will know that I'm not too keen on this due diligence business. And I often make the comparison with relations between neighbors on land, that if a neighbor is doing some damage to your property through activities on his or her property, well, there's a remedy. And why do we not recognize this in international law? But then aligned to this, I come to my 7th point, because the tribunal adds in nearly each case that it refers to this obligation of due diligence that, and I quote, and I can refer to what Professor Nilüfer was saying, the standard of due diligence is stringent, given the high risks of serious and irreversible harm to the marine environment from climate change impacts and ocean acidification. Now, I think we'll see doctoral theses dealing with this in the future. I'm not going to discuss what actually that means, but I must say it does remind me of the work that I did when I was on the International Law Commission on the topic international liability for injurious consequences arising out of action not prohibited by international law, a real mouthful, but I would note that work related to, and I emphasize, quote, acts not prohibited by international law. And I wonder whether inadvertently this is transposed over to the present decision. Now, finally, this is because of my own personal interest in my 8th and my final point relates to the negotiation of agreements on fish stocks, which negotiated between states, which occur within the exclusive economic zone of 2 or more coastal states. This is a task which has occupied me for 20 years when I used to work for my government. As pointed out by the tribunal, Article 63.1 of the Convention provides, and I quote, these states shall seek to agree on the measures necessary to coordinate and ensure the conservation and development of such stocks without prejudice to the other provisions of this part, and that part refers to Part 5 on the exclusive economic zone. Now, the tribunal reads this to mean that this obligation, quote, requires states to consult with one another in good faith, and I emphasize in good faith, with a view to adopting effective measures necessary to coordinate and ensure the conservation of such stocks. Now, this introduction of good faith cannot find a basis in the convention itself. In that particular area, though, we have Article 300, which may somehow be a reason to jump to that. And I know that this must have created led to a lot of discussion, and I look forward to some time when, in years to come, when we'll learn more about what in the minds of the individual judges when they discuss this. And again, that would also, that interest in mine also would be to what they were actually thinking. I would have liked to be a fly on the wall when they were deciding to use this term specific and then stringent. Well, finally, I want to turn to some reflections on what I have said. I've already presaged that in my premises what I feel at this time. So I will not be surprised if states find it difficult to move beyond their positions in the past on the basis of these decisions. Thus, as I've been saying in the lectures which I just referred to, it is for civil society to bring action in national courts to call on their governments to implement these obligations. I just had a conversation just before this began with a former Supreme Court judge who said in India, who said that in the 22 years that he had served on the 3 benches, in fact, he had never had a case of this nature presented to him. So this is understandable, I would have to say, because what? The opposing counsel, you can imagine the imaginary opposing counsel, if a case were brought before a court in India, would say, show me the law. So I leave you, dear colleagues, to say whether now an answer can be given to that short question from a hypothetical attorney general in the future. Thank you.
Thank you so much, Professor Gudmundur. Now, the first 2 decisions they dealt with the question of state obligations, largely within climate change treaties. Now, for the second set of the advisory opinions, this being the advisory opinion emanating from the Inter-American Court, as well as the request for advisory opinion directed towards the African Court of Human Rights. It's largely a question of state obligations in the context of human rights treaties. And to guide us in this discussion, I have the pleasure of introducing José Rodríguez, who is a climate justice advocate and international lawyer from Costa Rica. He has spent 5 years, from 2017 to 2022, working as a staff attorney at the Inter-American Court of Human Rights, and he has also served as a consulting attorney to the UN Special Rapporteur on Human Rights to a clean, healthy, and sustainable environment. José, welcome so much. Welcome.
Thank you so much, Albert. Thank you again to the organizers for the kind invitation to be here with you today. Just to have a little structure on my presentation, I'll first provide some context on the Inter-American Court's advisory opinion, how we got there, and then some key issues on the substance and the procedure relating to the court's advisory opinion and how it may relate to the hopefully upcoming advisory opinion by the African Court on Human and People's Rights. So going back to the beginning in 2022, I believe, 2021, end of 2021, the Inter-American Commission on Human Rights gave a resolution on the climate emergency and human rights, providing an initial blueprint of which were the state obligations under the American Convention on Human Rights, which is the regional human rights treaty. The equivalent in Africa would be the African Charter. And since then, before there were attempts to take climate cases before the Inter-American system, which had not succeeded. For example, a petition by the Inuit peoples against pollution caused by GHG emissions by the United States and Canada, which was dismissed on admissibility grounds without the commission even looking at the merits. So a lot happened between the early 2000s and the commission's resolution. And then there was momentum to get more legal certainty, on part because of the frustration with COP negotiations, but also there was a strong push from civil society to get this clarity from the Inter-American Court. And on this point, I think it's very important to understand that in the Americas, the Inter-American Court is of the opinion that its judgments are legally binding and create an obligation for all states, not only party to the American Convention, but that are members to the Organization of American States, so the equivalent to the African Union, to make sure their policies, judgments, and laws are, they respect not only the convention, but also the judgments of the court, which include advisory opinions. So there was a big push from civil society organizations to get a friendly state to submit questions on human rights and climate change before the Inter-American Court. And finally, in 2023, these civil society organizations succeeded in getting Colombia and Chile to request the advisory opinion from the Inter-American Court. And ever since, the proceeding was the most participative proceeding in the court's history. On this point, I think it's also important to keep in mind that the advisory proceeding before the Inter-American Court is one of the most participative process in all of international tribunals, in the sense that any state that is party to the Charter of the Organization of American States can request an advisory opinion, but also any individual, community, civil society organization, academic, university, indigenous peoples, they can participate and send their perspectives to the court. And this is exactly what happened. There was a very strong, again, push from civil society organizations articulating domestically and regionally to ensure there was the highest and most representative participation before the court, which amounted to nearly 300 written briefs and nearly 200 oral participations in the hearings that the court had in the Caribbean and in Brazil. And to get more on the substance, the decision was rendered in July of this year, before 1 week before the ICJ advisory opinion. And it was truly a groundbreaking moment for climate justice in the Americas. And I believe for human rights protection from climate change worldwide, as this was the first international tribunal to recognize that climate change is a human rights issue, and that climate change obligations stem not only from specific treaties, but also from human rights treaties, which are binding upon all states. Now, I won't go into much detail on the breadth of this advisory opinion, which is nearly 300 pages long, but I'll provide you some key points which the court touches upon. The first one, which I think is very important, is the duty of due diligence, the standard of due diligence. This is nothing new for the Inter-American Court. The court has always understood that for a state to prevent human rights violations, it has to have awareness of a foreseeable risk to a certain individual or group of individuals, and that upon that knowledge, it has to carry out specific preventive measures. And of course, the conduct and the responsibility of the state is assessed against those measures and not the final end result. Think of it as going to the doctor. The doctor is under an obligation to provide all the treatment, the best treatment available, but is not under an obligation to save your life, right? That's the goal which doctors aspire to. But what will determine the doctor's responsibility, for example, in a medical negligence case, will be what was the appropriate treatment for the patient. Did the doctor take all appropriate measures? And this is exactly what happens with the due diligence duty. And the court has extensive decisions on this standard, specifically regarding the search of people who have been victims of enforced disappearance, but also in the carrying out of judicial proceedings in a timely manner. And so the court applies this standard, which also comes from general public international law and international environmental law, and applies it to mitigation and adaptation duties. In my view, this is the way the court compatibilizes the principle of common but differentiated responsibilities and respective capabilities and human rights universality or universalism. What I mean by this is that all states have human rights obligations to mitigate and adapt to climate change, and the way that they determine the appropriate measures is determined by different factors, including historical and current GHG emissions, current capabilities, which the court describes in great depth evidence that can be taken into account to determine states' capabilities, like a human development index, poverty rate, inequality rate, and also the circumstances the state is in. So this is very important because the court underscores that states are under a reinforced or strict due diligence standard, which is what the International Tribunal on the Law of the Sea had already said, and then what the International Court of Justice said similarly, that states have very narrow, limited discretion in determining the measures which are appropriate to tackle climate change. So it's not just preparing and submitting NDCs or national adaptation plans, but actually states have obligations under human rights treaties to protect these human rights from the effects of climate change, and they require, for example, preparing and determining a mitigation and adaptation target, which is binding upon the state, and also a concrete plan, a plan that is time-bound and that can objectively achieve the result of the target. And this has to be based on the best available science. So this is an overarching standard of care that applies to both mitigation and adaptation measures, but also to other duties that the court identifies, like cooperation measures and the duty to repair human rights violations caused by climate change impacts. Now, the court also provides a very rich development of its already existing jurisprudence on the human right to a healthy environment under Article 26 of the American Convention. And the court has held, similarly to UN experts, that this right has both substantive and procedural dimensions. The substantive dimension protects the elements of the environment, like the biosphere, the ocean, air, but also the climate system. And the court had already, in previous cases, recognized, for example, that since clean air is part of the right to a healthy environment, you can derive a right to breathe clean air from the right to a healthy environment, and that carries on a set of specific obligations to prevent air pollution. So the court took the same approach it had taken in the La Oroya decision, which was a mining case in Peru. And it applies it to the context of climate change and says the climate system is protected by this right. And therefore, states have very specific measures to guarantee and respect, protect, and fulfill the right to a clean climate under the right to a healthy environment. Sorry, a healthy climate. And this right protects the interests in its collective dimension. Again, it's not only substantive and procedural, but also collective and individual. Regarding the collective dimension, the right to a healthy environment, but also the right to a healthy climate protects the rights and interests of nature and future generations, and individually, the right of all individuals to live in a climate which fosters dignified conditions of life, and that tackles human-caused climate change. And then the court goes into depth on the mitigation obligations under the right to a healthy environment. And it then, from the duty of due diligence, again, which is very criticized because it may be too flexible for states, but the court has had, since its 2017 advisory opinion, has clarified that because this standard is non-prescriptive, in the sense that states have a wide range of measures they can adapt, the court will not go into detail and say which all of them are, right? But it sets a minimum. And this minimum to prevent both harm to the climate system, but human rights violations from climate impacts, specifically regarding mitigation, implies concrete measures like carrying out environmental impact assessments that factor in the impact of an activity or a project on the climate system and on human rights. Regulation, supervision, and monitoring of corporations and private individuals that are causing this harm when they operate within the jurisdiction of the state. And at the same time, the court, keeping in mind that the Americas is not a continent which significantly contributes to climate change in terms of historical GHG emissions, the court is much more detailed and prescriptive when it speaks about adaptation, right? The measures states have to take to ensure human and nature's resilience to the impacts of climate change. And for example, the court speaks about the need to protect and prevent forced displacement from the effects of climate change, and also goes into a high degree of detail on the differentiated approaches states have to take to protect the rights of groups that are already known to be disproportionately affected by the impacts of climate change, such as indigenous peoples, women, children, and other groups which are disproportionately impacted by climate change. So I don't want to take too much time, but from all of this that I've already shared from a very dense decision, I have some key points which I think could be of interest for engagement with the African Court's advisory proceedings. First, I think it's crucial to always remember that this initially came from civil society, and that civil society did not stop at achieving an advisory opinion request, but rather had pressure through different actions and campaign efforts to influence the decision of the court. So working with communities, making sure their testimonies are presented before the court, ensuring indigenous peoples have the chance to speak directly before the court, coalescing regional human rights and climate change organizations and presenting a unified stance on what the minimum legal standards are, and presenting that to the court, speaking to the media. This sort of pressure is also relevant for framing the issues that are before international tribunals, as we have seen already before ITLOS, the Inter-American Court, and the International Court of Justice. But also, not only on the procedural aspect, but also on the substance, there are some key gaps that stem not only from the Inter-American Court's opinion, but also from the ITLOS and the ICJ opinions, which would be very interesting to develop further in an upcoming African Court of Human and People's Rights advisory opinion. These are specifically, what does a fossil fuel phase out looks like? What does it entail for different types of states, depending on their dependence on fossil fuels, for example? And also, how does that relate to the responsibility of transnational corporations? Now, the Inter-American Court did say states had a very strong duty to regulate and supervise private individuals and companies contributing to climate change, such as asking them to disclose their emission across their value chain. And the International Court of Justice also said that fossil fuel subsidies, exploration, and exploitation may breach a state's international obligation. But what exactly is required from states to ensure a fossil fuel phase out that is respectful of human rights? That is still an unanswered question, and it relates a lot to the PALU request on the issue of a just transition. There are some guiding principles in the Inter-American Court's decision on the just transition, such as those that are more impacted and have contributed the least, have to benefit the most and be impacted the least from the measures taken to transition. But I believe the African Court has an opportunity to really establish a roadmap for how just transition looks like from African states. I also believe that regarding reparations, the Inter-American Court was it developed its standards on reparations on climate cases, but it did not refer specifically to the duty states have to seek this reparation in international fora, for example, through litigation. And I believe that is also an aspect that the PALU request seeks the court to clarify. we know some conduct of some states causes climate change, causes climate harm. What are the minimum human rights obligations African states have to ensure that that reparation reaches communities, for example, that are most impacted by climate change? And finally, something that is very important that the African Court could also take into account is the whole development around the best available science. We have now 3 international judgments that say the IPCC reports constitute at least the minimum state accepted best available science that should guide climate policy. But the Inter-American Court goes deeper and says that states have to take not only these reports into account, but also produce scientific information to prevent climate change and adapt to its impacts, and crucially, integrate and work together with indigenous peoples to ensure that their ancestral knowledge that has kept the forests of the world alive are integrated into climate change policy. So it's not some only Western science, but also the ancestral traditional knowledge of indigenous peoples that needs to be taken into account. And on that point, I'll just close on some parallelisms and maybe a gap from the Inter-American Court. It did not really go into depth in analyzing the relationship between colonialism and extractive industries, and then how that determines risk exposure to climate change. The ICJ, of course, also didn't do that, but it did highlight the relevance of historical emissions. I believe because African states, including the African Union, presented very strong arguments before the International Court of Justice on this issue, that this should be replicated and hopefully give concrete meaning in the African Court's upcoming advisory opinion. For example, some states saying an adequate form of reparation would be debt relief or debt cancellation, which would allow for more funds from the state to be not put into debt, but rather into climate action. I'll stop there. I know it's a lot, but maybe we can go further into detail with the questions. Thank you so much.
Thank you so much, Jose. So I'd like to remind the participants, please, you can start pasting your question at the chat box. After the final speaker, you're going to be taking the question, so feel free to paste your question not on the chat box, but in the Q&A box. All right. Now we come to the final speaker, who is Mr. Donald Deya, who is the Chief Executive Officer of the Pan-African Lawyers Union and an advocate of the High Court of Kenya. He was previously the Chief Executive Officer of the East African Law Society, and as a seasoned litigator, he has appeared extensively before the African Court on Human and People's Rights and the East African Court of Justice. He's also actively engaging in advocacy with numerous African and international institutions, including the African Union, the African Development Bank, the African Legal Support Facility, COMESA, International Conference on Great Lakes Region, IGAD, as well as the East African Community. His work also includes engagement with the United Nations system, the International Criminal Court, to contribute to the advancement of human rights and good governance. And he was part of the lead team instituting the request for advisory opinion before the African Court of Human Rights. Mr. Donald, thank you so much for gracing us. The floor is yours.
And thank you very much, Albert, and the entire teams at Kabarak Law, Strathmore Law, and the international partners for convening this webinar at this important time. And I also acknowledge it's part of the International Law Month at Kabarak Law, in which I've participated quite a bit over the past month. I thank my previous panelists for having sufficiently analyzed the existing advisory opinions from the International Court of Justice, the International Tribunal on the Law of the Sea, and the Inter-American Court on Human Rights, so that I do not have to spend any more time on this. I will also try to shorten my presentation to allow more time for more interactive discussion and to deal with the questions and comments that have come from the participants, which really are addressed to all the panelists and not just to me. And I'll start by highlighting that of the key international courts and tribunals under discussion today, it is only in the African human rights system that non-state actors can lodge requests for advisory opinions. There's a very limited locus standi, but it is there. Article 4 of the protocol establishing the court says that an African organization recognized by the African Union can lodge a request for advisory opinion. Of course, also can member states and can organs and institutions of the African Union, or the AU in short. The African Court has interpreted this provision, African organization recognized by the AU, to mean an African organization that has either observer status or a formal memorandum of understanding on cooperation and collaboration with the African Union in Addis Ababa. So while the AU has organs and institutions spread throughout the continent, the court in Arusha, yes, the African Commission on Human and People's Rights in Banjul, the Gambia, the African Committee of Experts on the Rights and Welfare of the Child in Maseru, Lesotho, and even the Pan-African Parliament in Midrand, South Africa. Although all of these are AU organs, the court in its interpretation limited it to the AU organs in Addis Ababa. So few organizations have such a status, observer status, or an MOU with the AU in Addis Ababa, and PALU is one of them since 2006. And of the few organizations that have this status, very few use strategic litigation as a tool. For the moment, it's only actually PALU that we know of. So for the time being, it is only PALU that can lodge requests for advisory opinions, and which we have done successfully on a range of human and people's rights issues over the years. In the last couple of years, we have successfully lodged and got an advisory opinion on the issue of vagrancy laws and the interaction with human and people's rights. And most recently, we've gotten a successful opinion on the obligations of states to maintain popular governance during periods of global health pandemics such as COVID-19. We have others, we have at least one other, apart from the climate change one, that has already been filed and accepted. Now, breaking news. At around 1 p.m. East African time today, Thursday, 4th September 2025, the African Court has transmitted the request on climate change to member states and to AU organs and institutions, and it has invited them to file their observations within the next 90 days. So this has just gone out today at 1 p.m. In the previous practice of the court, it has allowed it has allowed a wide range of academic institutions, civil society organizations writ large, and other interested actors to apply to participate in court processes, whether contentious or non-contentious, as amici curiae or as experts. So as applicants, we're really inviting colleagues who consider that they may want to express themselves on one or another aspect of the questions that we put before the court to now feel free to do so, to apply to be amici or experts and so on, and to participate in that way. In our understanding of the practice of the court, even though it has given 90 days, it's likely to be able to extend, especially to enable member states that may want to express the same one way or the other to do so. So 90 days are a good marker, but it's likely to be extended. And as applicants, PALU and the African Climate Platform will particularly seek the engagement of science and evidence, especially cutting-edge science and evidence from Africa on the subject. And we're quite aware that the African Union has its own scientific, technical, and research commission, which, among other things, has produced a report on the climate change impact in Africa, challenges and opportunities within the realms of science, technology, and innovation, and which needs to be updated. To now go back to the specific questions that were asked of us. Of course, the distinction that African civil society organizations will be able to file requests means that the African system actually allows a wider range of actors, rather than just the states, to be able to initiate action and to be able to be heard with an element of equality of arms on some of the key issues affecting the continent and affecting the world. In terms of framing, indeed, the questions framed to the ICJ, to the ITLOS, and so on had global framing. There were general obligations of states under international law to ensure protection of the climate system, with an emphasis on intergenerational equality. In the Inter-American request, and of course also the AU request, this has regional framing and is framed in the context of the regional human and people's rights legal system. In our case, in the context of the African Charter on Human and People's Rights, its various protocols, and also other African human rights law recognized by the African system. In the ICJ, for instance, the question that was asked were obligations of states under international law to prevent, mitigate, and remedy climate harm, including consequences for states or other actors that cause significant harm. In our own request, we go further and ask what are the obligations of African states in the specific context of African human and people's rights law and their obligations, and how the human and people's rights obligations intersect with climate justice. And we focus on rights such as rights to life, right to development, right to food, right to health, right to the environment. And we place emphasis on state accountability within Africa. But naturally, it will express itself on state accountability also with states from the global north. While the other opinions relied on interpretation of customary international law, we have grounded ours squarely on regional human rights law and the legally binding obligations and duties of states. This should make it easy to translate whatever opinion the court will give, not just into litigation, subsequent litigation within the member states and within the courts of the regional economic communities, and even subsequent litigation at the African court, but this should also enable the opinion to influence lawmaking, so that when lawmakers, legislators are making law at the national level or the regional level, are making policy at the national level or the regional level, they will be guided by, indeed bound by the opinion that the court will give. So we're looking at a bottom-up way of making law through strategic litigation to influence subsequent processes at national level, sub-regional level, continental level, and globally. On the issue of just transition, again, I just echo what José have already said, that we expect the court to highlight the human rights obligations of states when it comes to the just transition. We hope that the court will stress that transition policies must allow Africa to develop, to industrialize, and to eradicate poverty. Again, on environmental defenders, this request is the only one that specifically mentions environmental defenders, highlighting their plight and highlighting their need for their protection. We acknowledge that the Inter-American Court's advisory opinion already provides a strong emphasis on participation, on access to information, and on access to justice. This was quite minimal in my understanding in the ICJ and the ITLOS opinions. We also address the issue of vulnerable petitions, and we specifically highlight vulnerable populations, and we specifically highlight how vulnerable populations are affected by climate change in Africa: women, girls, children, the elderly, and indigenous communities. We also address the obligation of third-party actors, private corporations, private actors, and non-African states. And we specifically ask the court to clarify what are the state's obligations to regulate corporations operating in Africa. And we frame the corporate responsibility with a decolonial justice lens, so that it addresses historical as well as ongoing extractive practices and other practices violative of human and people's rights, which, among other things, have fueled the climate crisis. We also bring out the point of intergenerational equity. We talk about ancestral rights and the rights of people of past generations. We connect this with ancestral land rights and religions of African communities, especially indigenous peoples. And we note that for some African communities, in their realm, rights and claims do not extinguish with death. And so to achieve intergenerational equity, the court will have to go into this. This opinion is also filed at a time when the question of reparations for Africans and persons of African descent for the historical crimes of chattel slavery, of colonialism, and of neocolonialism is very squarely on the table. It is a theme of the African Union for this year, 2025. The Executive Council of the African Union, at its recent meeting in July of 2025 in Malabo, Equatorial Guinea, has actually declared that they will extend the year of reparations to a decade of reparations for Africans and persons of African descent for historical and contemporary crimes and violations. So we're really keen to intersect climate justice and reparations for climate justice, especially adopting a very broad lens to reparations, which is something that my co-panelists have also articulated. So in terms of opportunities, again, speaking very briefly, I'll try to divide that into opportunities now, while the request is still being processed by the court within the African human rights system, and opportunities after the court renders its advisory opinion. One is agenda setting and narrative shaping. This request, especially the stage we're in now, where it's been opened up to participation by member states, by AU organs and institutions, and potentially by other actors, civil society, academic institutions, even non-African states and non-African actors, because the court adopts a very broad and purposive approach to amici curiae and experts. We're really able to put the agenda before the African people and before the world so that people can use the pending request as an advocacy hook to discuss the issues, to highlight Africa's unique position in the climate crisis, and to bring to the fore justice-based narratives, historical responsibility, reparations, corporate accountability, and the rights of future generations. It also gives us an opportunity for stakeholders to mobilize, especially in country, that academic actors, civil society actors can mobilize and engage their states and help their states to prepare and file meaningful observations and inputs. And in so doing, to be able to really amplify the voices of African people, especially marginalized people in global climate negotiations. This allows coalition building, including South-South mobilization. And this entire process really can influence even negotiations that are ongoing now, COP negotiations. At the UN, we're engaging in talks towards now a UN framework convention on international tax cooperation, basically a UN tax convention, and so on. So really, the process of engaging with this request can really influence lots of other negotiations where climate is an issue or climate is implicated. And it's an opportunity for us to really educate African citizens and engage them. After the opinion comes out, any which way, and we're quite hopeful and optimistic for a strong and clear opinion that lays out a number of issues, it will really have clarified the norms and how they apply and what are the obligations of African states and other actors in Africa or who engage Africa. So we really expect normative clarification, and this can be invoked, as I said, in national lawmaking, national policy making, and national litigation. It will give, an advocacy tool and also an accountability tool with which citizens, communities, and civil society can hold states accountable by citing the advisory opinion as an authoritative interpretation of the African human rights system and as a basis for strengthening claims for loss and damage finance, debt cancellation, corporate accountability, and so on. And once the African position is stated in law, we expect that this will influence global processes because this will be the minimum with which African states and African organizations will engage in global negotiations. And as I said, we hope that it also leverages the reparations discourse and enables the court to signpost or to sketch out very innovative and meaningful reparations that are not limited to the very traditional way that the international legal system has hitherto looked at the issue of reparations. So I think rather than go into more detail, I'd rather hand over back to you, Albert, and hopefully we've preserved enough time to engage with our audience. Thank you.
Thank you so much, Donald. Maybe I could start off the question and answer session.
Could I just make a short comment? Just to thank Donald now and before Jose for your comprehensive description of what is going on in Africa and what took place in Latin America, I would call it. I was very impressed with the way the Latin American case was presented to the court, and doubly impressed by the way that by your description, Donald, of what the African court can expect. Thank you, both of you.
Thank you so much. For the panel, for the participants, you're reminded to paste your questions in the Q&A session, in the Q&A box, and I will be taking them shortly. So as we do that, the first question goes to Donald, in particular regarding the request tabled before the African Court of Human Rights. One of the requests is an invitation of the court to consider the obligations of African states in respect of traditional emitters. And it is argued, at least in paragraph 144, that African states have an obligation to advocate for climate justice on the global stage and engage in diplomatic efforts to hold traditional emitting countries accountable for their historical contributions on climate change. Would you kindly expound on this?
Yes, indeed. Part of our aspiration there is that African states sometimes engage, or representatives of African states sometimes engage in global negotiations very meekly, from a position of weakness, and from a position that they probably will accept anything that sister states, especially emitting states, give them, that anything good is less than nothing. So our intention is really to ground the issue on obligation and to tell the states that you have obligations to your people, both under your national laws and laws made on the African continent, that should force you to be very robust and very well guided and very insistent in the negotiations that you make, in the points that you put forward in global negotiations, and the minimum that you bring back to the people of Africa, individuals and communities, because it is an obligation, not a discretion. So that is part of what I wanted to chase. And whereas, because we're going to try to go a bit further in terms of how else we can implicate collective action in Africa. Basically, an international law and international, under the African legal system, the obligations are to states parties that have ratified the various treaties, charters, protocols, setting out the African human rights system. But one of the things that we want to explore, using a third world approaches to international law framework, is what are the obligations also of AU organs and institutions that are implicated, that are the obligations to help states to achieve certain outcomes. So we're really going for a robust restatement of the fact that our states and our collective organs and institutions ought to do more and not regard this as discretionary or negotiate from a position of weakness. Thanks.
Thank you so much. So we have another question here. It's from Dr. Radwan. It's open to any of the panelists. It's not specifically to Donald. So the question is, to what extent do you consider these advisory opinions as a starting point for youth-led litigation or for renewal or for new regional campaigns in the context where judicial enforcement mechanisms remain weak? It was initially directed to Ms. Samira Ali, but she's no longer with us. So any of the panelists, you're welcome to answer that. I could take it again. To what extent do you consider the advisory opinions as a starting point for youth-led litigation or for new regional campaigns in the context where judicial enforcement mechanisms remain weak?
I can take that, if that's okay, Albert, or just some
Yes, please.
Initial thoughts. Well, it's key to acknowledge that, again, as Samira had said, it was the Pacific and the world's youth that spearheaded the campaign to take climate change to the International Court of Justice. And we were also very active with national youth across the continents. We have like regional teams from Europe, the Americas, Africa, Asia. We worked with youth which are already campaigning on the ground to achieve climate justice and precisely to facilitate the knowledge on how to strategically use the law as an additional tool to achieve the change they want to see in the world. And one of these areas of possible avenues for change is strategic human rights litigation. In the Americas, there have been some successful cases led by youth, for example, in Colombia and Costa Rica, but across the world, there's a lot of not only climate litigation, but also climate action that is being actively campaigned for and influenced by youth. The key thing I think here is not having youth as a tokenistic representation, for example, but that acknowledging that because those who are born now or that are younger will disproportionately face the consequences of inaction today, we have to have a role and a seat in the table. And the standards from all three advisory opinions provide a very strong benchmark to strategically use in cases that have already been filed, because it provides an authoritative guide for judges which may be unfamiliar with the climate issue. And so I believe, especially on the issue of intergenerational equity, that there may be more chances of success after the Inter-American Court's opinion. We had this case in Germany, the Neubauer case, where the German Constitutional Court ruled that there was a sort of intergenerational discrimination because the burdens of dealing with climate change were essentially pushed for generations to come. And the Inter-American Court has now ruled that that is contrary to states' obligations under human rights law, and that the interests of future generations need to be factored in climate policy, climate planning. So I think this could be a concrete area to ensure not only to justice, participation, and information youth worldwide that are already working to change the world in a positive way, and that can use these legal instruments as a tool in that endeavor. Sorry, and just to end with a partial break, the World for Climate Justice is always accepting volunteers around the world. You don't have to be a lawyer. This was a movement started by students, for students around the world. And if people listening to this call are interested in joining the movement, please just sign up our members form, and we'll be very happy to have you with us. Thank you.
Thank you so much, José, for the answer as well as for the invitation. So the next question is regarding the ICJ advisory opinion. And the question is, what is your take on the ICJ's treatment of intertemporal law and responsibility towards historical injustices through the use of the CBDR-RC principle? Since the stance of the IPCC has established that the emissions happened before the climate treaties were developed, does this then mean that using Max Huber's first limb of the intertemporal logic in the island of Palma's case, that the emissions can only be judged by the law at the time? It's a question about the intertemporal law and the responsibility towards historical injustices, especially that the historical injustices happened before the coming into force of the climate change treaties. Any of the panelists could help me.
I wouldn't want to take all the, okay, I'm Ambassador, and then I can also complement it.
Let me just make a comment that what we just heard really relates to international adjudication. And I think you heard just now from José and from you earlier, and then you and Donald for the future, that this will take place in national courts. And I would just add one thing, because there was a question also: how do you determine what are the standards which have been identified in these courts? Well, the court has to do it. It has no choice. It cannot say, as governments would obviously sometimes say, it's too vague and so forth. No, a case is before a court. It has to decide. That is a groundbreaking element here. Thank you.
Thank you. José?
Yes, no, just on the issue of intertemporal law, that was a big argument used by a lot of industrialized states before the ICJ, essentially saying that that the duty to prevent transboundary harm as a customary duty did not apply, but if it applied, it only started to apply from the moment the climate conventions were signed, because it was only until that moment that states had the scientific knowledge that their actions were causing this harm. The court really doesn't go much into detail or at all on this very contentious issue, which I agree with Professor Eiriksson that this will probably have to be resolved maybe through interstate litigation before an international court. At the moment, from where these obligations were binding upon the state. But the court does clarify that the duty to prevent transboundary harm is binding upon all states and applies to climate change. And we have knowledge, we have had scientific knowledge, at least industrialized states and the industries operating within those states have had very precise knowledge for a very long time of the very specific consequences their conduct would have. So that would, I believe, would rest on a specific case to determine how far responsibility can go in time. But the court does set some stepping stones by highlighting that the duty to prevent transboundary harm applies to climate change, and that historical responsibility is key for determining international responsibility for climate harm.
Thank you so much, José. In the interest of time, I'll read two questions, and then we can have the panelists answer them together. Actually, the first one goes directly to Donald. So the question is, when do we expect the African Union advisory to be submitted to the African Commission of Human Rights and communicated to member states? Secondly, AU has no regime for protection of environment human rights defenders, unlike Latin America and Europe. Do we expect AU to develop a regime for protection on environmental human rights defenders after the advisory opinion? So that goes to Martin. So the second question, it's about the advisory opinion of the ITLOS. So in its advisory opinion of 21st May 2024, ITLOS emphasized the principle of strict due diligence in addressing climate change. Do you think this opinion establishes a reinforced obligation of conduct, or does it implicitly move towards an obligation of results for states? Seems to be a question on classification. So we can have Donald going first.
Thanks. As I said earlier, the procedure that the African Court adopts when it receives a request is that first it carries out kind of a prima facie and a preliminary examination to determine that prima facie it's something it has jurisdiction to proceed with, which it did. It then explicitly refers the request to the African Commission on Human and People's Rights to ensure that the African Commission is not dealing with essentially the same matter in any of the processes before it. And when the Commission replies back and says, no, we're not dealing with this thing, then is when it transmits the request to member states and to various AU organs and institutions that are implicated, and gives a timeline for them to put in the written observations. So that is what happened today. Earlier today, the court has now written to the member states and to AU organs and institutions and invited them to make their observations and to do so within the next 90 days. So in principle, thereafter, at the close of 90 days, the court can close for deliberations and then issue its opinion. It's entitled to do that. The rules entitled to do that. But as I said earlier, in my understanding of the practice of the court over time is if it feels it has not received enough observations, or if it feels it needs to accord, especially the member states, more time, then it can decide, it has a discretion to decide to extend the period for putting in observations. But the matter now is out before the states, which means that the court has at least accepted it, allowed the request, and is willing to process it. So that is where we are. On the second question, the question of protection of environmental defenders, this was one of the issues that were of concern to us, which is one of the issues, which is why it's one of the issues that we tabled expressly, so that the court can provide, in our view, general guidance, which can act as an invocation to various parts of the AU, the Commission in Banjul and other parts of the AU, to possibly formulate stronger norms and stronger procedures around protection of environmental defenders, environmental human rights defenders within Africa. Thanks. Let me stop there for now.
Thank you.
So do you want me to answer this?
Yes, please.
Yes, well, of course, I think the ITLOS, the first question is, what is due diligence? Of course, we don't know that. ITLOS has set out a number of criteria which have to be taken into account and so forth. But I think, listening to José, I would say that is a court which has a lot of experience in various forms of due diligence. ITLOS doesn't. So it kind of added these elements together in order to assess that and so forth. Now, as I said earlier, if you read between the lines, I'm not so particularly happy about adding another vague term, that is strictness. Is it due? What's wrong with just due? If it's due process, strict or not, it should be left at that. But I won't. Of course, I'm not going to argue that. I hope to hear more from, shall we say, those responsible for using this terms as the term is specific. What is the difference between specific obligations and obligations? Obviously, there was some intention by the parties, by the judges to mean something by that, and similarly, they meant to mean something by the difference between strict and just normal due process. Well, we'll have to wait to see what shall we say, the practitioner, the scholars maybe will provide us information on.
Thank you so much, Professor Gudmundur. Now, in the interest of time, we cannot take all the questions. However, before I give Humphrey the opportunity to do a vote of thanks, I'd like to give the panelists an opportunity to give any final thoughts or concluding thoughts they may have before we come to the close of the webinar. So any of the panelists are welcome to give their concluding remarks.
Perhaps we go in the order in which we spoke.
That can work.
Well, I think I kind of jumped the gun and gave my concluding remarks. So thank you and José for your contributions, and they enhance the hope that I have that these things will make a difference. And I won't add more to that.
Thank you. We can have José.
Yeah, thank you so much again for organizing this event and inviting me and Samira as panelists here. I just think it's crucial to keep in mind that individuals have a role in shaping the law and states' response to climate change. And these advisory proceedings show how far grassroots power can go. And I look very much forward to see how we can contribute constructively and work with our African colleagues in this proceeding. So thank you so much.
Thank you so much as well, Donald.
Yeah, I really would like to thank Gudmundur and José, and of course our previous panelists who had to drop out at one point or the other, and also of course Kabarak and Strathmore Law and your partners for convening this at this time. It's been quite useful, and having this dialogue, especially with colleagues who have spent much more time analyzing the ICJ, the ITLOS, and the Inter-American processes and the results that came out is really useful for us as we frame what is the most we can achieve from the African court at this time. We were quite conscious when drafting and asking the questions not to be overambitious, not to ask too many questions and risk invoking or inciting the law of diminishing returns. So it was quite a challenge. But the scope in terms of the questions that we asked for various actors, African and non-African, to offer to engage in the process as amici and so on, so that we deepen what we have. And I've seen the question by Giscard, and that's the point at which I will end. We do not see this as a fragmentation of international law on climate. We see this more or less as a progressive consolidation and a progressive deepening and a progressive, contextualization, so that we are contextualizing, for instance, for Africa, but starting with the minimum of what has been agreed upon at the global level, and then going deeper in terms of our entire system of laws and practices and the approaches of the AU, rooted in Pan-Africanism and in TWILE, third world approaches to international law. So thank you very much, and everybody have a good rest of the day.
So, Humphrey, please forgive me. Let's talk about youth. I cannot resist telling everyone the most effective speech I've ever heard at the UN. And I've heard thousands of speeches, made many myself. And this was in a reception in which there was the so-called assembly of young people from all over the world. And the guest of honor was Kirk Douglas. Now, none of you are probably old enough to know, but he was a very famous, only recently passed away at a high age. And he said, and he did it very effectively because he had kind of lost his voice. He had a stroke, and he could only speak very slowly. And he began by saying, "You will think that what I," and so forth, is going to be very profound because he spoke like this. But all I want to say, he said, was that we have failed. My generation has failed. And we now look to the youth to salvage all the problems of the environment. It was in that context. I thank you all, particularly the young among you.
Thank you so much. It's been a pleasure moderating this panel. I now hand over to Humphrey Sipalla to close the panel discussion for us. Thank you so much.
Thank you, Albert. Thank you, our audience. Thank you, the panelists. My heart is full today. Let me start with a few thoughts before my vote of thanks. My Law of the Sea professor, a certain Professor Gudmundur, who is here, when we were discussing a certain then prospective Law of the Sea dispute, gave me this quote, and he said, this line, he said, "Hard cases make bad law." And this has always troubled me. I think this is one series of hard cases. Even from Prof Gudmundur's own reflections today about due diligence. I think you've always asked this question, even about the good faith principle from Max Planck and all that. The courts are progressing our knowledge about the obligations of states in the climate emergency. And a lot of questions still need to be answered. We all welcome the African Court request, the request to the African Court. It allows us to even take the conversation further. But allow me to say this: international law is the law of political idealists. International law frames and progresses and solves problems of the time. And even in the difficulty of the questions today, the progress is being made. Today, I flee to the worries of Doudou Thiam, the Senegalese foreign minister in the 1960s, who began to frame the question of the right to development. And I see in the context as which was also raised of the energy transition. Climate action will require energy transition. Energy transition will require making difficult decisions whose due diligence is not clear. African states want to develop, have a duty to develop, an intergenerational duty to develop, but also to develop within climate action. The challenges ahead are fascinating, and I think, the steps that will be made in national courts, in regional courts, in subsequent litigation before the same courts will continue to progress the conversation. José framed that even in the Inter-American system, the Inuit peoples began this question before the Inter-American Commission 2 decades ago. So there is that sense of progress in international law towards the ideal. I think African states really have an obligation to, it's an opportunity with this request before the African Court for African states to shed their usual stance as defendants of human rights cases, and putting really their observations about where they think the conversation should go, and in the context of the right to development, which is a right specific in the African human rights system, and what common but differentiated responsibilities to African states mean in the context of the right to development in climate action. Allow me to thank the panelists, Samira, who had gladly accepted to join us for a bit, Prof Nilüfer Oral, our partner today, along with our co-host Rashmi, Prof Gudmundur, thank you for joining us again in this, hopefully the second of many other conversations we will have about climate action litigation. Deya, thank you. We have been together during the International Law Month, I think thrice now. And I thank you for your conversation. And to José, we woke you up at 5 a.m. Thank you so much for joining us today, all the way from San Jose. The International Law Month at Kabarak began in July, and it was supposed to last a month. We began with a conversation on space law and sustainability of space, legal aspects of sustainability of space, and the place of global South states and peoples. Then we had a conversation on the legacy of Bonaya Godana, a Kenyan, a former Kenyan foreign minister, a leading, I think actually Africa's first international freshwater scholar. Was a moving conversation that we had there. We had 2 webinars that we co-hosted with Palu here and my brother Don on 25 years of the Constitutive Act of the African Union. I thank the current and former AU legal counsels and colleagues in civil society who joined us for these conversations. And today we close this. I would like to thank 2 people who behind the scenes really helped to put together this webinar. Patricia Tare, who was my supervisor at the Inter-American Court, joined us in the first conversation, was really behind the scenes helping to put together this webinar. And Professor Phoebe Okowa, who has, from the first webinar, she kept on saying we must have another one to think about what the requests have answered. We thank them for their continued collaboration. I'd like to thank the audience. Remind them that the recording is available on the Kabarak University Press YouTube channel, along with the recordings of the other webinars we've had during this month. I'd like to mention that we have a new blog on international law named in honor of Bonaya Godana, the former Kenyan foreign minister. And we look forward to continuing these conversations on what are the aspects of international law that impinge on the global South. Lastly, I thank my good friend Rashmi for co-hosting this webinar with us, and to everybody who's here, who's joined us. I hope I've not left out anybody. I mean, it's been 2 months of a 1-month conversation in various aspects of international law. Kabarak University Press feels honored. Thank you so much, everyone, for having joined us. Thank you.
All right. Humphrey, stay on a second. I'm going to tell you an anecdote about Dudu Tiam. I don't think you've heard before. No, we'll let everyone go who wants to. So just call me back.
Okay, I will. Thank you so much, Prof. Thank you, everyone. It's been an absolute honor.